Mr. Parker, you've got August, Maribel.
Yes, Your Honor.
Maryville, August, Maryville.
That's, I haven't followed anything.
Good morning.
Morning.
Mr. Nichols only agreed to dismiss 4 of them.
I think I even counted. I think I told him at least 7. So it's 4. He may have more than me.
Yeah.
Good morning. Are you August Maribel? And Mr. Maribel is charged with theft of property with previous convictions. There are 13 cases. Starting with cause number 26 DCCR 0347. Then we've got 0876 77 78 79 80 81 82 83 84 85 86 and 1029. And Mr. Parker, what is the announcement?
Your Honor, I've talked to him this morning and previously at the jail. He's indicated that his family's working on hiring his own lawyer, so he's requesting the reset to be able to hire his own lawyer.
So, Mr. Maribel, if I reset your case, it'll be about 30 days or so. Do you think they can get someone hired?
Yes, sir.
So Mr. Parker remains your attorney, unless you get another attorney. And so he'll remain on your, case, start looking through everything, visit with you about it. If someone else is hired, then they'll file a motion to substitute in and we'll get that taken care of. If for some reason they don't get someone hired, then when we come back next time, you'll need to be talking about, what your options are with Mr. Parker, okay? All right, go back to the bailiff.
You just, and there's one other case that White's representing.
Hold on just a second. Where's Mr. Kimler?
He's right there.
He's fine.
Mr. Kimler, on Jeremiah Branch,
Jeremiah.
He has 4 previous cases and he has 2 new cases. And Kelly put me on those, but Mr. Kimler says he's gonna handle those as well.
is that correct, Mr. Kimler?
Yes, sir.
So if you'll get a notice filed on, I only see one new case.
Well, all I have is 1 new case, but she told me 2. I may be totally wrong. I mean, I have,
Smith,
it may be 1.
so Mr. Smith, on Jeremiah Branch, I have, a new offense of 26 DCCR 1168. Is there something else coming or is that?
I think that was the new one, Judge.
Okay, I thought there was like 2. I may just.
So you're Jeremiah Branch?
Well, there's 26 DCCR 0958 and 26 DCCR 1168, the 2 new cases.
I've got Mr. Kimler on one of those new cases, but not the, Mr. Kimler.
Not the latest.
Yeah, I don't have. any-
1168 is the latest one.
Yeah.
He was also indicted 3 weeks before that on a aggravated robbery.
1168 is what I don't have.
Yes, I have the indictment.
That's the one
I'll
he's taking up under. I'm sure.
Okay, thank you. All right. So if you'll get a notice filed on that, Mr. Branch is charged with aggravated robbery, assault on a peace officer, robbery, and then the last one is another robbery allegation. What is the announcement?
He has a bond, I suppose. There's an NTRP.
Have you filed a motion for a bond or what do you?
We're asking for a bond on the NTRP. NTRPs.
Did she print out the orders on those? Is that this?
Yes, ma'am.
Okay. Thank you. So clause numbers 25 DCCR 1382, which is an assault on a peace officer, and 25 DCCR 1385, which is a robbery, are both motion to revoke probations. And there are no bonds currently set. Is that correct in those cases? And Mr. Kimler has filed those. request that I set a bond in each of those cases. It's like there's been a first amended filed in each of these. So he was placed on probation February 3rd of 2026. In both cases is 10-year deferred probations. And the allegations are a new aggravated robbery from April of 2026. Testing positive for cocaine on several occasions, failing to submit to drug or alcohol screening on several occasions, failed to comply with Texas Drug Education Program, a new offense of evading arrest or detention from February 6th, resisting arrest or transportation February 6th. And so, Mr. Kimler, you may proceed.
Well, Your Honor, they're deferred adjudicated probations. We would just request a regional MTRP bonds. If the bonds are denied, we would request a disposition on the MTRPs within 20 days of request for the bond pursuant to the
Yeah, but
code of criminal procedure.
is there any evidence with regard to your client's ability to make a bond or?
Well, Your Honor, I think he's entitled to a bond. I haven't filed a writ to challenge the amount of the bond because it hasn't been set yet. So I'm waiting for the court to set the bond. If that's excessive, then I would follow.
If I'm gonna set a bond, I need to have information on what his ability is so that I don't set one and then we're back in here.
I could elicit that.
Raise your right hand the best you can, please, sir. You swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, go ahead.
Mr. Branch, please inform the court of your current financial situation.
I get a $1,000 every month and disability.
And other than that, do you have any
I
income?
have food stamps. And I was gonna look for a part-time job too.
What is your disability that prevents you from working?
Seizures, but they told me I could work like I could work like 30 to 4 hours a day.
Go supplement your,
Yeah.
do you have any assets? You own your own car?
I don't own my own cars.
Are you,
My mom gave me my mom not able to give me a ride.
are they giving you medication at the jail?
Yeah, they just put me on the new medicine and it's been working good with everybody on the dorm say I haven't been having seizures or outbursts.
What medication are you on?
I've been trying to get the name of it, but I try to ask my nurse the name of it this morning, but I was sleeping.
Are you functioning okay now?
Yeah, I'm functioning way better now. I haven't, but when I got here, when I first booked me in, I had like, they definitely in the booking was on. The booking, the front booking for like 4 days. And I had like 5 seats there.
If the judge grants you a bond and you're able to get out, would you follow up maybe as a condition of your probation or a condition of your bond with MHMR
Yes, sir.
to continue the treatment?
Yes, sir.
And as far as your other financial assets, you don't own your own car, do you rent, or where do you live?
I stay with my mom.
And your monthly expenses about what are these? As far as food,
She pays the bill and I'm on food stamp.
password.
No questions, Judge.
It's for the record, I'm taking judicial notice of the court's files in all of the cases. And so give me just a second that I'm right now going over the probable cause affidavits and those 2 new offenses. Then I'm gonna need something else as well. Any witnesses, Mr. Smith, or just argument?
Just argument.
All right, give me just a second then.
Oh, my dude.
Yes, sir.
Almost there. Give me just. Also reviewing the pre-sentence report from the two cases where he was placed on probation as well. In January of this year. So there was already information when he was placed on probation in January with regard to some mental health issues, and that was addressed. So he was placed on the mental health caseload. So it looks like that's not a new information, that he had some. Okay, Mr. Smith.
Judge, I understand that these are deferred cases, but the state is opposed to setting bond based on the nature of the crimes that he was on probation for and the nature of the crimes that he committed within 2 months of being placed on probation for these first robberies. He, on top of the 2 felonies that are filed, there's also evading and resisting that are pending in misdemeanor court. He has failed several drug tests. He's refused to take other drug tests, indicating to me that he is probably under the influence of illegal narcotics most of the time. And for those reasons, I believe he is a danger to our community, and I would request no bond in these cases.
I would just add, Your Honor, if the court refuses to set a bond, requesting us disposition within 20 days of their on the MTRPs.
So here's what I'm gonna do, Mr. Branch. So the underlying offense that you're on probation for is a robbery and an assault on a peace officer, and the robbery occurred at Delaware Food Mart. Went in, attempting to steal, assaulted the clerk, and then they held you there while the police got there. And here we are 2 months after you got placed on probation, or 3 months after you got placed on probation for a robbery of a store. And we've got 2 additional robberies of the same store 3 days apart that are alleged. So obviously I agree with Mr. Smith. I think that you are a danger to our society. I am going to set bonds. I'm going to set bonds in each of your cases at $300,000. Conditions of those bonds, if you make them, are that you are on house arrest with a GPS monitoring device, and then we'll set your case for the appropriate hearing. Right?
Thank you.
Thank you. Both cases, 1382, no, this is on 25 DCCR 1382 and 1385, the 2 MTRPs. I didn't do anything on the others. Where's the order? Sentencing on Ebony Broussard.
That was actually. That was actually. This is. Actually.
Smallfino here. All right, we need to wait for Miss Smallfino. If we can just have her wait just a minute. LaAsia Clemens, Mr. Kimler. Is also Miss Smallfino's.
She's got others. She's ready. I know some others in this case.
Is Ms. Holmes here?
She just went next door.
This is set for.
So obviously the case that Mr. Kimler's on is the one that would be the one that is set on the pretrial, and the other one is a new evading arrest. Ma'am, are you Laisha Clemens? And Ms. Clemens is charged with robbery and cause number 25 DCCR 1339. Excuse me, that case is set for trial to begin with jury selection next Monday. There is another case of evading arrest or detention with the use of a vehicle. I don't show that you've been hired on that one. Ms. Holmes represents her, but I would think that the robbery would be the issue we need to take care of first anyway, so.
Judge, I have, if I may, spoken with Ms. Holmes about that case. Also would appreciate the opportunity at this juncture to speak with Mr. Kimler again about the original offer that she rejected now that she has been back in custody and has a new felony.
Let me
I
hold
don't
up.
know that that might not dispose of everything. Otherwise, I will have an announcement here very shortly. for the
Okay,
court.
I'll hold it. Y'all visit real quick. And then we also have a sentencing on Ebony Broussard. Let's take care of that, and then y'all can talk on Ms. Clemens. All right, you are Ebony Broussard,
Correct.
and
Yes.
this is cause numbers 19-32518, 19-32806, and 21-36615. Ms. Broussard is on probation in the 32518 and 32806, was put on probation January 21st of 2020. 10-year deferred probations. One was escape while arrested, and the other was the second-degree assault on a peace officer. And then was placed on probation July 12th of 2021, and the clause number 21-36615 for a 5-year deferred probation for a state jail felony offense of possession of a controlled substance. She was here previously, entered pleas of true to counts 1 through 5 in that motion to revoke in each of the cases. There was no agreement. I received the pre-sentence report update. Have y'all both had an opportunity to review that update?
I have, Judge.
Are there any additions or corrections or anything on that?
Judge, I have just a quick comment. I'd also like to ask Ms. Richard or Ms. Fenton if they have anything for the court. They've been very involved in this case.
Anything that's not in the report that you think is important?
No, Your Honor, everything that we have in there is very direct and support.
All right, thank you.
And my only position, Judge, would be that she's obviously been extended almost every opportunity that probation has, every class, every structure, every program, and it would not be the position of the state like it typically is to argue for safety. In fact, I would argue strongly against it.
All right, Mr. Kimler.
I suppose, Your Honor, in response to that, she has demonstrated an ability to complete the programs, which is reflected in the pre-sentence report that she has been ordered to attend. Of course, there is a pattern of conduct that reflects addiction and substance abuse, but she also has the ability to complete the programs as well. I don't know how that relates to her inability, I suppose, to cope with the substance abuse issues, but she does have the ability at least to have enough structure and conform to the structure of these programs to complete them. So that says something. It looks from the pre-sentence report, it would be asking a lot to continue her on probation, especially with probation probably being unwilling to, or at least reticent to do that. I would only ask the court, if the court is considering the developer to consider something at the lower end. She does have children. And I'm not trying to use that as an excuse or anything, but they could maybe perhaps.
Children she was on her way to get while she was under the influence of PCP.
I don't know that they established conclusively that she was under the influence. I mean, again, it reflects the substance abuse problem, but she
She
does.
played true to all of the counts.
But yeah, that's true, Your Honor, and it reflects a continued struggle with substance abuse.
Yeah.
And so the issue then is going to be probably, I'm looking probably incarceration, but I would just ask that it be something not extreme, or at the upper end. And she wanted to address it. What do you have to say?
I do take accountability for my actions, but however, I have completed ISL before. And if you will be willing to work with me again, I would appreciate it. I have, before I was incarcerated, I did enroll myself in outpatient classes, which was referred to me through Ozark when I went got assessed. And I was taking AA classes as well. I did complete 5 of the classes, however, I wasn't able to complete it because I was incarcerated. I do still have my job, and I did complete my 5-year probation for the first conviction. And I do pay my.
So is the time, it was told, I mean, because of the
been told.
motion. So yeah, I mean, you did the 5 years, but
Yes,
it's
ma'am.
not over.
Yes, ma'am. I
still-
understand.
What is, Ms. Malfino, do you have any position with regard to specifically punishment on these cases?
Sorry, Judge, I was just looking back at the original
Yeah.
PSI.
Yeah.
I do, thanks. Obviously, the court sees that she doesn't prior to this have any type of felony conviction, Judge, so I'll defer to whatever you think is appropriate, just in the context that they have given her so much of their efforts.
So, Ms. Broussard, you've been given the opportunity of, looks like you went to Franklin North way back in 2017. And then you get on probation. You went through JCDI, but you couldn't complete it because of progressive sanctions for continuing to not follow those rules. Then you went to Franklin North, December 7th of 2020. You were on the drug patch program. You did that. You went to anger management. You went through the moral recognition therapy. You were on the high medium caseload. You've been to ISF. And despite all of that, you're still on 2 probations, one of which you could get 20 years in prison and the other 10. You still haven't figured out how to stop using drugs. And you were in fact in a vehicle going to pick up your young children from daycare under the influence of PCP.
Oh, man. However, when I went to Franklin North, it was because I was in a toxic relationship. And that's what the day did.
So, but here's, okay, how old?
And
How old are you? How old are you?
I'm 42, man.
Okay, so you've been through what appears to be years of drug addiction. And at 42 years old, and you've been on these probations for 5 years or more, you've had every opportunity handed to you to try to help you, and you're still using. So at this time, in clause number 19-32518, I'm going to find counts 1 through 5 true, find sufficient evidence to find you guilty. And at this time, find you guilty of escape while arrested, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 19-32806, find counts 1 through 5 true, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for the time that you've been in custody that the law gives you the right to receive. And then in cause number 21-36615, also find counts 1 through 5 true, find sufficient evidence to find you guilty, and at this time finds you guilty of possession of a controlled substance. Sentence you to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All of these sentences will run concurrently, which means together at the same time. I'm going to hand you the trial court certification that shows there was no agreement. You do have some rights to appeal. You need to sign that with your attorney, and then I'll give you that copy. Also, I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Do you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts? You can talk with Mr. Kimler.
Right here. And what is the statement? And I'll wait on that.
It's saying that you do have a right to appeal, and Mr. Kimler will talk to you about that.
When do you find?
You hand her that one and just the bottom copy off of that one, Mr. Kimler.
When can I find the spare time?
They'll do the judgments today, and it should show up in the computer probably in the next day or two.
Mr. Jill does not give us this information.
It's well, right now it hasn't been all calculated, so it'll be in the system in the next day or two. Once the clerk, she's in court right now, so she can't do it, but it'll happen the next day or two. Mr. Burbank, you've got Leroy Harris. Do you see a rejection on Harris?
Just send it, Your Honor. Here you go.
Good morning. Are you Leroy Harris Jr.? And this is cause number 24 DCCR 0404. Mr. Harris is charged with the first degree felony offense of murder from December 3rd of 2023. And Mr. Harris, that indictment alleges that you were previously convicted of robbery May 9th of 2012. And also in 2 cases on that same date. And what that means, sir, is that if you go to trial in that robbery case and the murder case, and the robbery case is true, that conviction, then you would be considered enhanced punishment, which means your punishment would be, if you're found guilty, a minimum of 15 years, up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here on the tablet, and I'm making that notation that I've admonished them to the enhanced. It shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 40-year term in the murder case with a dismiss in the pending felon. What pending felony is there? Well, that's the
It's an
MTRP.
MTRP.
So really wouldn't be a dismissal of it. It's just the MTRP on a state jail felony. It looks. Well, so I'm gonna mark through that also. Whatever happened, if you took that 40 years on the murder, then something would be figured out with the state jail felony motion to revoke that would run concurrently or at the same time. Correct?
Yes. And Judge, I apologize. I think Mr. Burbank and we were trying to talk over a bunch of people. That should be 30.
30,
Yes.
not 40.
Correct.
So is it, okay, so Mr. Harris,
I don't think it makes a difference, but just the paperwork.
so the offer is for 30 years in the institutional division of the Texas Department of Corrections. Do you understand what your options are if you wanted to enter a plea of guilty? And do you want to reject that offer and have your case set for trial? All right, we'll get it set on the trial docket, and Mr. Burbank will begin preparation for trial.
Thank you, Anna.
Thank you. Yes.
And Judge, just may I, for the record,
Yeah, hold on just a second.
why this case is the age it is obviously the court is aware. Mr. Harris, having been in Harris County, there has subsequently been a conviction over there for murder. I believe it was a lesser included of a capital. He received 12 years on that. It will be my intention to get from Ms. Rogers, the DA over there, what I can, probably a PSI, and get that to Mr. Burbank, but it just adds a little bit of supplemental discovery just at this juncture. So we'll keep the court informed if that changes our negotiation. I'm just not quite at this point in a position to make any other offer. If I am, I'll come to the court first.
Okay, thank you.
Thank you.
All right, you can go back with the bailiff. And then you've got Asa Jones, Mr. Burbank.
I think we previously.
Yeah, this is pretrial for Monday. Morning, Mr. Coleman. Mr. Coleman, I've heard some
I know, Judge. It's unfortunate. I'm a team player. Judge.
very unfortunate news.
Team player. I go where the coach.
I don't like that team.
I
I
go,
like the team I've got right
I
now.
go where the coach tells me as a member of the team.
Team is being downsized.
The team is being downsized. Right, sir, you're Asa Jones. And this is cause number 25 DCCR 0963. Mr. Jones is charged with a first-degree felony offensive aggravated assault. And the case is set for trial to begin with jury selection next Monday. And what is the announcement?
You should be ready to.
State your ready.
All right, it is likely going to be at the top of the list. I have one other that's potential, but it sounds like there might be some issues. So, but you'll know today after docket. I do want to make sure you understand, Mr. Jones, that after today, I will not accept any plea agreements. It looks like I've got a plea bargain rejection from January of this year where you rejected a 25-year term. Has there been any change in negotiations?
No, Judge. Your Honor, we have a witness that would ask the court, call the name of, please.
Okay,
Atlanta Gallo.
Atlanta Gallo, please.
We asked that the court admonish her, she's under subpoena, admonish her about the consequences of not showing up for the trial next week.
If you'll just have her come over here on this side. Good morning, ma'am. And your name's Atlanta Gallo?
Yes, ma'am.
And Ms. Gallo, we're here in clause number 25 DCCR 0963. And Mr. Jones' case is set for trial for next week to begin on Monday. You are placed under subpoena for that. And I just want to make sure you understand that it is required by law that you show up whether you want to or not for court next week. At whatever time the district attorney tells you and whatever time that subpoena told you, you have to be here. If you don't come, now that you've been given this order and that subpoena, there could be some consequences where you would get in trouble. Do you understand?
Yes, ma'am.
You could be held in contempt of court. There would be a fine. You could potentially go to jail yourself for not showing up. Do you understand? Okay. All right. You're free to step back out.
Thank you, Judge.
Excuse Judge.
All right, anything else then? So, Mr. Jones, I do want to make sure you understand that after today, I will not accept any plea agreements. And again, it's very likely that your case will be at the top of the list. Mr. Burbank will know that after docket today. Do you understand?
Yes, ma'am.
Okay, I'll let you know after docket then.
I have to excuse you.
Yes, sir.
About that. I talked to him and.
Ms. Perazzo, you've got Logan Eaglin.
Logan
Mr.
Eaglin.
Smith.
Logan.
Good morning.
Sorry, I got his. Still yesterday. Yes.
Good morning. Are you Logan Eaglin?
Yes, ma'am.
And this is cause number 26 DCCR 121123. Excuse me. Mr. Eaglin is charged with murders. Case is set for trial to begin with jury selection next Monday. What is the announcement?
Your Honor, so there is some additional discovery that was just provided to me, and I have not had a chance to review that with my client. So I would like just one more brief reset so I can visit with him and go over all of that discovery.
So I guess my question is, if it's just going over discovery with him and making him aware of all of that, then I feel like that's something that could take place soon, today, go over everything. If there's any change, y'all could let me know unless there's some other investigation or information that you're still waiting on or you need to find out.
No,
Okay, well, do you want to?
there is, I mean, it was. An additional witness has come forward. That this defendant has made a admission to about committing the crime. But it is another inmate, so we would, I don't know. I think if they want time to investigate that, maybe even having try to interview him. State would not be opposed to that, not opposed to resetting it one time for trial.
Is that your intention?
Yes, Your Honor.
Okay, so I'm going to, and it was also, it looks like it's been reinvited. This is the third reinvite.
Yes, Judge.
So, which, I mean, the information that you have is all the same, other than the new information that you just got yesterday, is that
Yes, and
correct?
then I also got some new media yesterday in this case.
So here's
as
what
well.
I'm going to do. I'm going to reset the case 45 days on an announcement docket. That way, if there's any change in, well, actually, I'm just going to reset it on announcement 30 days.
Yes,
If you
ma'am.
need an investigator, you can get that, make that request
Yes,
quickly.
ma'am.
We'll get you the funding for it. That way, if they need to go visit with any additional witness, let's try to get it all done within 30 days. If something changes and there's some deal that we reach on the 30th day, great, then we'll take care of it. If not, it'll go right back on the trial docket at that point instead of us waiting 3 months for another trial docket.
Yes, ma'am.
Okay, all right, you can go back
Thank
with the
you.
bailiff. And then you got Thaddeus McCray.
Yes, ma'am.
Can you make a note on either when I look up the new clause number, none of the old that has been brought into that new clause number. So I don't put any of the objections or anything in their way for all, I need everything to be transferred to the new case. And it's probably from those two prior, not just one, but two prior indictments. All right, so you're Thaddeus McCray. And Mr. McCray is charged in cause number 26 DCCR 0399 with the first degree felony offensive murder. And in cause number 21 38959, we've got a motion to revoke probation for an aggravated assault causing serious bodily injury. And what is the announcement?
Your Honor, essentially it's the same announcement that I just made previously on the last case. There were some items that were missing from discovery that I requested. They were just recently responded to and provided. I'm not sure if everything that I asked for was provided, but I need to review all of that and go over that information and evidence with my client just
Okay.
to ensure that we have everything.
Sure, so we'll do one more reset. Is there anything else that you know of that you're waiting on that she does not
No,
have?
Judge, these were things that she had asked for that weren't in the file that we went and got.
Good,
and brought
okay.
into the file.
So, Mr. McCray, I'm just gonna reset your case, a normal reset for about 30 days. That'll give Ms. Prazo some time to come go over all of the new information that she's received. At that next full day, we'll need an announcement whether or not you're gonna go to trial or if there's some deal that's reached, okay? All right,
Judge.
thank you. Mr. Rojas, you got Jaden Brantley.
Brantley, Jaden Brantley.
Okay, so she's gonna, they did work it out. So Mr. Kimbler, Ms. Holmes is gonna take care of that
Yes, ma'am.
for you. Okay,
I've
perfect.
told them that. I
Okay,
have told the advisor.
thank you. Good morning. Are you Jaden Brantley?
Yes, ma'am.
And this is cause number 26 DCCR 0422. Mr. Brantley, you're charged in that case with the first degree felony offense of aggravated robbery from February 6th of 2026. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 25 years in prison, which means you would be leaving your punishment up to me. And if I follow the agreement, I cannot give you more than 25. I could give you 25, I could give you less. It would all depend on the information that was brought to me at a sentencing hearing. You have every right to reject that offer, have a jury decide if you're guilty or not and what your punishment is. I just want to make sure you understand what the possible consequences are if you go to a jury trial, what your options are if you wanted to plead guilty. And do you understand all of that? And do you want to reject that offer and have your case set for trial?
You want to set up a trial?
Do you want to visit with Mr. Rojas again?
You talk some more?
Okay, I'll hold it. And if you need some time to go out and visit, just let me know. I can give you a week or two, but I'll hold it for a little bit.
Yes, ma'am.
All right, go back with the bailiff. And I'm just I'll have that on here.
Okay.
If you still want it, it'll be here. Oh, you got Manuel Cardenas. It's a sentencing, Mr. Rojas. Good morning. Are you Manuel Cardenas Jr.? And Mr. Cardenas was previously in court, entered a plea of guilty and cause number 26 DCCR 0040 to the third-degree felony offense of injury to a child, elderly, or disabled individual. And that was for an agreement of 5 years deferred probation. I received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
I have, Judge.
Any additions or corrections?
Not from the defense.
Judge, my only position would be that obviously as indicated by the PSI, this incident not stem from his criminal history, so to speak, but more likely probably a mental health or a narcotics induced incident. It's obviously concerning with regard to his father. We'd ask that a no contact order remain in place, but defer to what you think is appropriate.
Okay, so Mr. Cardenas, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That includes, among other things, but that does include that you will enter and successfully complete the safety program. So that can help you with any drug or alcohol related issues. When you get out, you will also be placed on the mental health initiative caseload to help with any other issues that you may be having, so that you will have all the tools to be able to be sober, healthy, and obviously not have anything like this happen again.
Yes, ma'am.
You will also be required at this time to have no contact or communication with Manuel Cardenas Sr., your father. That's until further order of the court. And so if there becomes a time on probation where you feel like you're in a good place and he wants you to be around or something like that, you have to go through probation. You have to get my permission to do that. He can't give you permission.
Okay.
So he can't say it's fine, come over, it's Christmas. If you do that without my permission, it's a violation of your probation. Okay. If you do everything you're supposed to on this probation, you're about to get all the tools you need to be successful. You don't have a felony conviction. You should be able to finish it. And at the end of your probation, if you're successful, the case is actually dismissed. You'll never have a felony conviction on your record.
Sounds good.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and I could send you to prison for anywhere in the punishment range, which is between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir.
Okay.
Mr. Vasquez, you have Corey Como.
Me?
Oh, I just saw him. Did he go somewhere? Well, don't call. I don't know where Joel is, so I'll skip that. Let's see. Mr. Rojas, you got Jimmy Couch. You're here for Bruce?
Yes, ma'am.
Okay, I'll take care of that. Just a second.
Yeah, I know that. There you go. How you felt? You know, you do that,
This is computer stuff.
Good morning, Judge.
Good morning. Are you Jimmy Cal?
Yes, ma'am.
Y'all give me just a second. Just.
We're gonna wait and stop. We can know that it's attempted.
That's coming. Mr. Couch,
Yes, ma'am.
pay attention this way. All right. Will he waive the formal reading of the indictment?
He will, Your Honor.
Mr. Couch, in clause number 26, DCCR 0328, the state has elected to proceed on the lesser included offense of a third-degree felony, attempted burglary of a habitation. And that's from January 29th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a 3-year deferred probation. There will be a $500 fine. You'd be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Oh, yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Couch is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. Ms. Malfino?
Judge, the state would respectfully object to any type of PSI bond in this case because of the fact that we're going to very strongly urge the court to consider safety. I have met multiple times with the complainant, Ms. Couch, in this case. She is actually present in court today. I think there is an underlying severe substance abuse issue that has contributed to all of these issues. And that will be the position of the state to ask for safety. And I'm afraid that if he's out in the interim, it will derail that and also this absence of contact with her at this point.
So,
I understand that's the state's position.
Sure.
Mr. Couch is requesting that you do consider allowing him to be released. He's been in jail now for
4 months.
4 months. He's getting some taking AA classes in jail.
From Rocco.
He's got some health issues that he desperately wants to get on the outside and
Yes, ma'am.
get addressed.
I have a spot on my lung. I was supposed to be in Baptist Hospital for another PET scan and another biopsy. And it's just getting worse by the day.
well, here's, if Mr. Rojas, if you want to get some information to the court between now and sentencing, I can bump something up with regard to a bond hearing. But today, based on the allegations and the concern, what I'm going to do is not change the bond. I am going to ask probation to do go ahead and get a substance abuse assessment during that so that we have everything in place when we come back for sentencing. All right, you
Thank
can go back with the bailiff.
Okay, thank you.
So on Bregan Hulsman, that's the one you talked to me about, right?
Yes.
Mr. Did y'all,
We did.
oh, okay, sorry.
Actually, it'll be a misdemeanor since he can do it.
Good morning. Are you Bregan Hulsman? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Hulsman, in cause number 26 DCCR 0199, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault. And that's from January 7th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for, hold on, it's back. A 2-year deferred probation. There would be a $250 fine, and you would be required to follow all of the rules and conditions of probation. Part of that would be that you would follow any recommendations with regard to any mental health care issues. Do you understand? State tenders number 1.
No objection.
It's admitted. And are you a U.S. citizen? All right. Is there any evidence that Ms. Hulsman is not competent?
None that has not already been addressed, Judge.
Okay. All right, then, Ms. Hulsman, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of the plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $250 fine, and you're ordered to follow all of the rules and conditions of probation, including any mental health care. If you do all of that, this is a great opportunity because you won't have a conviction on your record. And at the end of the probation period, if you successfully complete it, the case is dismissed. The other side of that is if you violate any condition of probation, you can be brought back into court and you could be convicted and sent to our Jefferson County Jail for up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You'll get some instructions from probation today so that you'll know exactly what to do when you're released from jail. Make sure you do all that, okay? All right, you can go back. John McMillan. Mr. Rojas. And Ms. Muffin, no.
Hold on that for just 1 second.
Sure.
Well, call, I sent a letter, I need to go grab a speaker on that.
Okay, I'll hold it. Ms. Shipley, you're here on Brandon Lewing for Mr. Smith.
Yes, Your Honor. Right.
Morning.
Good morning. But I feel
It may take you down the right now. It's still the people part.
Good morning, sir. You're Brandon Lewing. And Mr. Lewing is charged in cause number 25 DCCR 1402 with the state jail felony offense of unauthorized use of a vehicle. Ms. Shipley's here for Mr. Smith, and is there an announcement?
Judge, yes, Your Honor. Mr. Smith had to be in another court, and so Mr. Lewing and Mr. Smith have been working on some things, and they were able to provide Ms. Malfino with some additional information. And we're asking for a little bit of time for Mr. Smith and Ms. Malfino to consult on those matters.
And Judge, I have spoken with Ms. Shipley this morning. That is correct. Mr. Smith sent me an email from the defendant yesterday, and since he's here, if I may, I would just like the defendant to know I have taken it into consideration. I have rewatched the video, although there is a portion of his email that I agree with. respect to the ski mask, I just want him to know where I'm coming from.
Sure.
His stack of felonies that is this high doesn't lead me to take everything he says in that email that is self-serving to heart, but I will, based on that, be willing to discuss with Mr. Smith reconsideration of the offer if the court would allow us that time, but I just wanted Mr. Lewing to know I did look at that and what my position is.
Okay, so we'll just do a normal reset. That'll give your attorney and time to visit with Ms. Malfino, and when we come back, we'll get an announcement at that next court date.
Thank you.
Thank you, Judge. And then
Right.
Mr. Smith will be out to see you as soon as he meets with Miss Muffy. Thank you.
Michael Martin, also, Ms. Shipley.
Yes. This is a request for a
Michael Moore.
evaluation.
Has something been filed? No. Okay,
But that's where he's going.
so this is, we don't need Mr. Martin. I'm gonna reset it. If you'll get Mr. Smith, if he needs, so because he's hired, if you'll make sure if he needs, is requesting a court appointed evaluation for competency, make sure he also attaches the affidavit of indigency. That gets missed sometimes, and because you're hired, I have to have an affidavit of indigency and to make that determination before someone's appointed. Otherwise, you guys would have to get that taken care of with his.
Absolutely.
Okay, makes sense?
Yes.
All right. And so he's reset Michael Martin.
Yes, ma'am.
Mr. Vasquez? Lost him again. Let's see, Mr. Lewis, Ms. Holmes, you've got Brianne Williams, sentencing.
Brianne Williams.
Good morning. Good morning, you're Brianne Williams?
Yes, ma'am.
And this is cause numbers 26 DCCR, excuse me, 0531. Ms. Williams entered a plea of guilty in that case to a new offense of possession of a controlled substance, a third-degree felony. And then we've got cause number 1830512. Ms. Williams is on probation for injury to a child, and that's a third-degree felony offense. Entered pleas of true. Let's see, I see where. While I look at that, but there was an agreement, it appears, for a 3-year deferred probation, $500 fine, and ISF substance abuse track on the new case with continuing probation and ordering substance abuse, ISF substance abuse on that one. I've received the pre-sentence report and gone over it. Have y'all both had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Let me go back and look at something. All right, so it was a 10-year deferred probation from May 20th, 2019 for that injury to a child or elderly, excuse me, individual. And it looks like she pled true to counts 1 through 5, which include that new offense of failure to identify, a new offense of public intoxication, being an out past curfew, and court assessed fees. So I guess what I have a question mark here and an issue and a question, which is why is it just 3 years on a third degree felony possession when we've already got a 10-year deferred on the other one? I just don't know that that makes sense to me for it to be that low of a number of years for a new offense while you're on a felony offense. I'm not opposed to the ISF and do it and going forward with probation, but I just don't think it makes sense to do
It could have been the length of time.
That she had already been.
Right, because the new case, the new offense was from 2024, did not get indicted until this year. So I think that played a part
Okay,
in it.
but it was, okay, but it still was after she was on probation,
Yes,
but it
ma'am.
didn't get indicted for
And
a
I
long time.
believe when it originally occurred, that was addressed at a previous MTRP hearing. But it did not get indicted till 2 years later.
Okay, all right. Anything else then?
No, Your Honor.
No.
All right, Ms. Williams, with that explanation, I'm going to follow the agreements that you made with the district attorney's office. And cause number 26 DCCR 0531, find sufficient evidence to find you guilty. However, I'm going to follow that agreement and in that case, defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation, which includes entering and successfully completing the substance abuse track of the of ISF. And then in cause number 18-30512, I'm going to find that you enter those pleas of true to counts 1 through 5 freely and voluntarily, find those counts true, find sufficient evidence to find you guilty and revoke your probation in that case, but I'm not going to do that. I'm going to follow the agreement, continue you on probation, order as a condition of that probation that you enter and successfully complete the ISF substance abuse track as well. You're being given now all the opportunities that you're probably going to be given. So you're going to go to ISF, you'll get the tools you need in order to remain sober. When you get out, you'll have aftercare. You still have no felony convictions. You still got some great opportunities here to kind of get your life back on track, get off drugs and just live a normal life. If you don't do that and you don't take advantage of this and you continue to test positive and do the things that you did on this one, you're going to end up back in here and you could go to prison in each of these cases for up to 10 years. Do you understand? All right, I'm handing you the trial court certifications in each of those cases that shows that these were agreements that I followed, and so you waived your right to appeal. Good luck to you, ma'am.
Thank you, Judge.
That's the Jerry Johnson.
Carl Farrow.
I should put something on the record. You're gone.
Okay. Good morning. Are you Carl Farrow? This is 26 DCCR 0100. Mr. Farrow is charged with the state jail felony offense of unlawful possession of certain copper or brass material from October 30th of 2025. And what is the announcement?
Your Honor, if we can get a little bit more time. I've met with Mr. Farrow. This case involves whether he had authorization to possess these copper materials. And he's relayed to me that he does have documentation that had given him the authorization. And so if we could have some time so that he could get that to me.
Okay.
Yes.
All right. So I'm going to do a normal reset, Mr. Farrow. Make sure whatever information you have, you get that or your family or someone gets that to Ms. Holmes as quickly as possible so that she can then visit with Mr. Smith about it and then be back out to visit with you before that court date.
Thank you.
All right. You can go back with the bailiff. Donnie Smith. What?
We got bond reduction.
This isn't how we communicate. It's for me because it's a bond forfeit. I now have to say out loud, and make certain findings if they've had previous bond forfeitures, if if they end up playing in sentencing. So I have to have them now look up that on everybody. Mm-mm. If they're really not really like leading up to the docket, then yes, you have to go back and look and they can tell you about that. Good morning. Are you Donnie Glenn Smith?
Yes, ma'am.
And this is cause number 26 DCCR 0072. Mr. Smith is charged with assault on a peace officer. And what is the announcement?
Well, Your Honor, he had previously pled, but he didn't appear for his sentencing.
Oh,
And so,
okay.
yes, ma'am. So we that did all that, but he didn't appear.
He pled, Judge, that there was no agreement as to the type of probation.
Do you
Or
have
The
a-
type and.
any time.
Is there a PSI? It shows a status hearing, but I should have, it was set for sentencing and he didn't show up, and so there was a bond forfeiture. So I should have a PSI on Donnie Smith. I don't, it's
If you
not in the
don't mind.
case.
I've got two
No,
copies.
because I'll have notes and,
Okay.
all right, just, y'all can hold him for a few minutes. Let me, figure out where that is.
Yeah.
Mr. Lewis, you've got, Wacy Bork. Morning. There's no,
No, Judge, he informed me this morning that he's been able to try to retain him, somebody else, his own attorney.
thank you. Good morning. Are you Wacy Bork?
Yeah.
And this is 25 DCCR 1213. Mr. Bork is charged with the state jail felony offense. Excuse me, of theft of property. That indictment alleges 3 prior state jail felonies from different dates, which means for punishment purposes, this could be considered a 3rd-degree felony with a punishment range of between 2 years and up to 10 years. And Mr. Lewis, what is the announcement?
Judge, initially came in planning to place this on the trial docket, but after speaking with Mr. Bullock this morning, yeah, I guess after his conversation with his family, they'll be able to retain his own attorney.
Okay,
So I asked that he have at least have that opportunity, at least one setting before the case is placed on the trial.
so Mr. Bork, I'll reset your case to normal reset, which is about 30 days. Mr. Lewis is going to remain as your attorney. Unless you get someone else hired. If you do, they'll file the appropriate paperwork to substitute in for him. If for some reason that doesn't happen before the next court date, then we'll need to go forward with you visiting with Mr. Lewis and see where we get on your case, okay?
Just not gonna ask a question.
What's that?
My time wouldn't go up. I mean, I should be able to get a lawyer, but my time wouldn't go up like I'm playing with you or nothing like that.
No, there's been no
The
reduction.
offer is what the offer is. It's probably,
Okay.
it's not going up or down at this point for any reason. If he wants to get his own attorney, he has that right. I'm not
Okay.
holding that against him.
Sure.
Thanks.
So that'll remain on the table. That's between y'all at this point. Once there's a rejection later in front of me, then things kind of change as far as accepting plea agreements later. But it sounds like Mr. Nichols is going to leave that on the table for you. Okay? All right, you can go back with the bailiff. Thank you, Mr. Nichols.
And Judge,
Yes.
while we have Mr. Nichols up here, we had the Antonio Riggs on the docket.
Uh-huh.
And before he's brought up, I wanted to speak with you about him. We definitely have a competency issue with him.
Judge, just to fill you in, he was found competent back like in February.
Mm-hmm.
I've been, Mr. Lewis has informed me as he seems to have deteriorated some. I checked his jail screen. He has a history of seizures and things like that also affect him. So I think he probably.
We need a new
Need-
evaluation.
Yeah, and his family's here. They've come and been speaking with me, as was their interactions with him over this time. And
Okay.
he's definitely deteriorating, gotten worse.
Okay. I'll reset the case. If you'll make a notation for us to do the order for an evaluation on Mr. Riggs, please. And,
Yes, no.
and just make a notation. We could even do,
Sorry.
whichever one we didn't use. Leave that other. Okay. Thanks. You can, we're gonna reset Mr. Riggs. And then you've got, Christopher Fair.
Yes.
Good morning. Are you Christopher Fair?
Yes, ma'am.
And this is 18-30684. Mr. Fair is on probation for indecency with a child by sexual contact. There's a motion to revoke that's been filed. And what is the announcement?
Judge, at this time, we're prepared to plead the truth for several violations.
Okay, just go through and set it for
Right.
hearing. Give me just a second. And will he waive the formal reading of that motion?
He does.
Mr. Fair, best you can, please raise your right hand. Do you swear or affirm the testimony you give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yeah.
So, Mr. Fair, I have before me a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation December 2nd of 2019 for the second degree felony offense of indecency with a child, and that was a 10-year deferred probation. Is that correct?
Yes.
It alleges that you violated your probation. Count one alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. And is that true or not true?
True.
Count two alleges that you failed to provide verification of performing the community service hours required. Is that true or not true?
True.
Count three alleges that you failed to successfully complete an approved sex offender treatment program by a licensed sex offender treatment provider. Is that true or not true?
True.
Count four alleges that you are behind in your court assessed fees as of December 9th, 2025 in the amount of $3,290. And is that true or not true?
True.
Count five alleges that you failed to immediately report to the probation officer your phone number, employment, and that you now have an email. And is that true or not true?
True.
Count six alleges that you failed to report by mail or online to the Jefferson County Probation Department for the months of February, March, May, June, July, August, September, October, November, and December of 2024. And then January, February, April, May, June, July, August, September, October, and November of 2025. Is that true or not true?
True.
Count seven alleges that you committed the new offense of possession of marijuana January 21st of 2026 in Walker County, Texas. Is that true or not true?
Not true.
Count eight alleges that you committed the offense of unlawful possession of a firearm by felon January 21st of 2026 in Walker County, Texas. Is that true or not true?
Not true.
Count nine alleges that you committed the offense of possession of drug paraphernalia January 21st of 2026 in Walker County, Texas. Is that true or not true?
True.
Count 10 alleges that you committed the offense of failure to drive in a single marked lane January 21st of 2026. Is that true or not true?
True.
Count 11 alleges that you committed the offense of having no valid driver's license January 21st of 2026. And is that true or not true?
True.
And count 12 alleges that you failed to immediately report to your probation officer that new arrest. Is that true or not true?
True.
Did you enter your pleas of true? See, the easier way to do this. Did you enter your pleas of true to all of the counts except 7 and 8 freely and voluntarily?
Yeah.
And did you plead true to those counts because they're actually true?
Yes.
All right, then I'm going to find that you entered your pleas of true to all of the counts except 7 and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. But I'm going to reset your case for a hearing. Ms. French, do you anticipate that you would try to get anyone from the county to prove those allegations of 7 and 8, or just go forward on what he's pled on?
I think we can go forward on the 10 and split on.
Okay, so then we'll get an updated pre-sentence report done. Anything that you think is important for me to know, make sure you get that information to Mr. Lewis. He'll present it to me on your behalf when we come back. All right, and go back with the bailiff. Clifton Keller.
Clifton Keller. Keller. Keller.
Good morning, sir. Are you Clifton Keller?
Yes, ma'am.
And Mr. Keller's case in cause number 25 DCCR 1462, he's charged with arson. His case is set for trial to begin with jury selection next Monday. And what is the announcement?
Judge, before we even make that announcement, I have been in contact with Mr. Nichols. The state has made a new offer of 5 years TDC, which my client has rejected, and we are ready for trial.
Okay,
State's ready for trial, Your Honor.
let me make, so it looks like the previous. So it looks like there was a previous offer that was rejected of, it looks like 15 years in prison, and that's been reduced for an offer today of 5 years. Is that your understanding, Mr. Keller?
Yes, ma'am.
And you want to reject that and have your case go forward with trial next week, is that correct? All right, we'll get that done. I do want to make sure that after today, I number the cases after this docket. There will not be any other plea agreements after today. Do you understand? Unless there's something that comes up that nobody knows about. So I'll number the case and I'll let the attorneys know after docket. All right, you can go back with the bailiff.
This what do.
I made a new version of that old plea bargain rejection, so I can write that on there. If you need, I don't know if I need to tell you that or not. James Moffett, Mr. Lewis,
Judge, that's been dismissed, or at least I sent a dismissal.
Hey, he just wants
did I already sign a dismissal? James Moffett, I'll do that in a minute. That's fine. When did you send it today?
Yes, yes,
I see it, Judge, I'm sorry.
Okay, I'll sign it and Mr. Moffitt's free to go back.
he's in federal custody, Your Honor.
Oh, well, then, never mind. Let's. Did you have anything else?
Had a hearing that was set for 11, Judge.
Oh, okay, all right.
But to be honest with you, we actually worked out an agreement with you, so I'm gonna go with the state, so whenever you're ready to take.
Okay. Perfect, thanks. What did that happen with Mr. Parker's Marvin Watts? Mr. Nichols, on Mr. Parker's had one case on a Marvin Watts. Did we,
I was just looking at that, Judge.
would y'all send him a message and see where he went?
I believe Mr. Watts has 2 cases. So I think maybe it's kind of a confusion if that one's on the one and not the other. But I don't know.
I've got, yeah. Mr. Rojas, Jaden Brantley.
Yeah, I spoke with Mr. Brantley, his grandmother's looking at hiring an attorney. So if we can just give him a regular reset to give him time to do that.
Okay. And I'm gonna delete that rejection then.
If he
He's,
doesn't-
Brantley can go back.
Yes, ma'am.
And what about John McMillan?
That's gonna be a plea, Judge.
All right. Okay, John McMillan.
John McMillan.
It is Class A.
Yes.
They did do that purpose.
Good morning. Are you John McMillan?
Yes, I am.
And this is cause number 26 DCCR 0517. I'm going to take judicial notice of the court's file. There was a request and Mr. McMillan was evaluated for competency to stand trial. Dr. Krapon provided a report dated May 29th of 2026 with the finding in it that Mr. McMillan is currently competent to stand trial. Any other evidence with regard to competency?
No, Your Honor.
No.
All right, then at this time, I am going to find Mr. McMillan competent to stand trial, and Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Judge, with the court's permission, we proceed on a lesser included class A assault on this, just so the court knows. I have sent multiple letters with lack of response. That's the reason for the law.
All right, thank you. So, Mr. McMillan. Again, in cause number 26, DCCR 0517, the state's elected to proceed on the lesser included offense of a class A misdemeanor assault. And that's from March 8th of 2026. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with?
Yes, Your Honor.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And are you a US citizen?
Yes, Your Honor.
State tenders number 1.
No objection.
It's admitted. All right, Mr. McMillan, I'm going to find that you entered your plea of guilty freely and voluntarily. Again, I made that finding already, that you're competent to stand trial and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a class A misdemeanor assault. Sentence you in accordance with your agreement to a term of 9 months in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal.
Yes, Your Honor.
All right, good luck to you, sir.
Go, please.
Thank you. Thank you. Mr. Vasquez, you've got Corey Como.
Good morning.
Good morning.
Good morning, ladies. So you have videos and stuff, right? Yeah. Okay. Always on that. I believe he's indicted last month, so I don't think everything's.
You've already made those requests,
Good morning.
Mr. Vasquez.
Yeah, sure. He was indicted, I think, May 6th. I don't think.
Good morning. Are you Corey Como? And this is 26 DCCR 0826. Mr. Como is charged with the first-degree felony offense of murder. And what is the announcement?
Judge, it's on me at this point that Mr. Vasquez doesn't have paper discovery. It was not part of my file from the onset. I've requested and received it from Beaumont Police this past week, and it's being added to discovery. It's dozens of pages of police reports and stuff like that he doesn't have yet.
Okay.
So we're getting that to him.
And any videos also, I would assume?
There's a lot to voluminous, Judge. and he
Okay.
Needs to get all of that.
All right, so what I'm going to do is just do a normal reset, about 30 days or so. We'll see where we are at that time. Hopefully, Mr. Vasquez will at least have everything. And then if there needs to be some more time at that point to go over it or investigate, we'll talk about it then. All right, so he'll be out to see you as soon as he gets all of that information. All right, you can go back with the bailiff.
Thank you.
And then Raymond Sweet.
You know, when I talk to you.
Is he back in his office? Just reset it a week. I don't know if, we're gonna reset Mr. Watts just a week. I think there was some miscommunication on, with Mr. Parker on that one. Okay, you are Raymond Sweet. And Mr. Sweet's case in cause number 25 DCCR 1531 is set for trial to begin with jury selection next Monday. And what is the announcement?
Your Honor, Mr. Sweet has rejected a 25-year offer and a offer of a 30-year cap.
Okay.
And we're ready for trial.
State ready?
State's ready.
All right, so Mr. Sweet, I've got a new plea bargain rejection. I don't know, I can't remember if it's different, but anyway, it looks like there was a 25-year offer or a cap of 30 years, and we've gone through that before. And your indictment, which alleges at least 2 prior convictions. And that if you are found guilty and those convictions are true, the range of punishment would be between 25 years minimum up to 99 years or life. You understand all of that?
Yes.
Right, then I will number the cases as soon as docket's over, and Mr. Vasquez will be given that trial order for next week. All right, you can go back with the bailiff.
Thank you, Judge.
Thank you. On Ms. Holmes, are you ready on LaAsia's Clemens?
Yes.
Okay.
Yeah.
We've got, you have worked out with Mr. Kimler, agreements in both cases,
Yes.
correct?
I'm not sure, did Mr. Cameron do it? Discover?
Yes.
Okay.
Let's see, this is, Ms. Malfino's on Ms. Clemens. And you got the other.
Two cases.
All right, ma'am, are you LaAsia Clemens? And Ms. Clemens, Mr. Kimler represents you in one of your cases. Ms. Holmes represents you in the other. It's my understanding you've talked with both of them this morning and have agreements with regard to pleading guilty in your cases. And are you okay going forward with just Ms. Holmes going through this paperwork and stuff with you? Okay. Will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Right, Ms. Clemens, in cause number 26, DCCR 1179, you're charged with the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from May 20th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? And then in cause number 25, DCCR 1339, you are charged with the 2nd-degree felony offensive robbery from September 9th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes and or Mr. Kimler? Do you fully understand them? And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached in each case is for a 5-year deferred probation in each of your cases. There would be a $500 fine in each case, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? You also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. Speak up, please. State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Clemens is not competent? Right, ma'am, I'm going to find that you entered your plea of guilty in each of your cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty, but I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. Ms. Malfino, what is the state's position with regard to bond?
Judge, I would defer to the court. My only concern is obviously the fact that she picked up a new offense while the underlying offense was pending before this court. With the deferred offer, that's what it was originally. She had just rejected that. That's why we got to the trial docket. I don't.
My inclination is to leave it the way it is so that I can see if there's any other requirements or recommendations that probation might have so that we can make sure Ms. Clemens is going to be successful. All right, we'll see you back at sentencing.
Thank
You can go back with the bailiff. Is Mr. Johnson coming today? Or did we, that was reset? So I've got Carl Farrow.
We already did that one. That was reset.
Oh, we did. I meant to say Donnie Smith.
Okay.
Which one is that? That one? Oh.
This is a weapon forfeiture. Agreed weapon forfeiture.
All right, are you Donnie Smith?
Yes, ma'am.
This is cause number 26 DCCR 0072. Mr. Smith was previously in court, entered a plea of guilty to. Just like that. To the second degree felony offense of assault on a peace officer. We took that plea, reset the case for sentencing, and then Mr. Smith was not present for sentencing. I issued a bond forfeiture. The pre-sentence report was already done and he was arrested and we're back here now. And so I guess a couple of questions. One, Mr. Coleman, is the state still ready to proceed and go forward with sentencing?
We are, Judge, with the understanding that there is no agreement to the type or the length of probation.
Correct. And so it was, the agreement was for a probation, but not agreed as to whether it was a deferred or a straight probation and the length of time on that probation. Have you both had an opportunity to review that pre-sentence report?
Yes, Your Honor.
The state has to.
Any additions or corrections to that report?
None from the defense, Your Honor.
None from the state, Judge. If we could have just a brief moment, brief argument, please.
Sure. Ms. Holmes, you may proceed.
Yes, Your Honor. And looking at the PSR report, it appears that all of the current pending matters all occurred on the same day. Which is out of character, obviously, for Mr. Smith, who has no previous criminal history. He had no previous juvenile history. And so on this day, he was experiencing, he has been diagnosed with a few mental health situations such as bipolar disorder, ADHD. And I think a part of that is why he acted out on this particular day. He is aware that his actions have brought him here and he is remorseful and he knows that if given the opportunity on probation, he will abide by the rules and do what needs to be done to successfully complete probation. It's also important to see that they evaluated him at a low risk level, which means they feel that he is a probationer that would benefit from specialized programs with probation, as well as with the mental health services, and they don't feel that he would likely reoffend or be an issue on probation. So I believe that's very important for the court to see. Your Honor, we are asking that due to his lack of criminal history, that he be afforded the opportunity to be placed on deferred probation to show that he can abide by the rules. Obviously, we will be requesting that he be placed on a mental health caseload as well. To aid with that. And also he wants to get his GED. As the court can see, Mr. Smith has an 8th grade education and did not go to high school. And he does want to get his education and get his GED so that he can have gainful employment and help to provide for his family. And Your Honor, we are asking for deferred probation. The length of time, obviously, whatever the court deems necessary, but we do believe that deferred is the best for this situation.
Why didn't you come to court for sentencing?
I didn't have no transportation at the time and I was sick.
Did you call your
I
bondsman?
called the bondsman. They said there was nothing they could do about it. I tried to get a hold of my lawyer and she didn't answer. And I called the courthouse and they said just try to come in later on that day. And I had no transportation. I have transportation now though.
Mr. Coleman?
State will concede that the defendant has no criminal history. However, I think the probable cause affidavit doesn't do justice in describing what happened there, Judge, between this defendant and Sergeant Noah Visser. This was an all-out fight, Judge, and it went on for some time. This defendant struck Sergeant Visser in the face. It went on. They went to the ground. They went on for about at least a minute until backup units arrived and were able to assist. It's regrettable that I could not get Sergeant Visser here today so that I can enter into evidence and play for you the video of that incident. I suspect that the court would find it very probative as to what you would do. But it was an all-out fight, not like one of these deals where they're just wrestling and tussling and somebody kicks somebody or somebody elbows somebody. This was an all-out fight, Judge. In my opinion, that's what warrants or merits a straight post-conviction probation as opposed to a deferred. Judge.
Thank you, Mr. Coleman. I can just tell from the police version in here without seeing the video that this is different than a typical assault on a peace officer that we get where, like Mr. Coleman said, I mean, this, I don't know what was going on, but it also seems like it was very out of character. I agree with Miss Malfina, Miss Holmes, that something was obviously going on that day. What I'm gonna do, Mr. Smith, I'm going to find that you entered your plea of guilty previously, freely and voluntarily. I'm going to find sufficient evidence to find you guilty. I'm going to give you an opportunity today because I'm not going to find you guilty. I'm going to defer all proceedings, but I'm going to place you on probation for 10 years. So I had considered a straight probation with less time, but if I'm going to give you that opportunity for deferred, it's going to be a long probation. If you do everything you're supposed to on this probation, there's no reason you couldn't even get off of it early, but it's going to make sure that we know that everything that you need is getting taken care of. I am going to order that as a $500 fine and order that you follow all of the rules and conditions of probation. That is going to include participating in any mental health care services through Spindletop. If they say you have to do something, even if you don't think you need it, it is now part of your probation. So you're required, if it's medication, if it's counseling, whatever. In addition, I'm going to order that you get your GED. I'm glad that you want to do that. It's not going to be easy since you stopped school so early, but it's still possible. You can do it. And now you're going to be required to do it because it helps everybody if you do that. So I'm going to order that you start that process within 45 days of today. So you don't get to wait and say, well, I've got 10 years to get my GED. I want you to get that GED because it's only going to help you do better in life. If you do everything you're supposed to in this case, this is the best opportunity of your life today to make some real big decisions that change your life because you don't have a felony conviction on your record. And if you're successful, the case will be dismissed at the end. You'll never have a felony conviction.
That's cool.
The other side, it's great because having a felony conviction changes everything. You can't get certain jobs, you can't live certain places, you can't vote, you can't have a firearm. I mean, the list is long on how bad having a felony conviction is. So you've got that opportunity today. If you violate any condition of probation, then you'll be back in here on a motion to revoke your probation. You can be found guilty, which means you'll get the felony conviction. And then I can send you to prison anywhere in that length of time of the punishment range, which is between 2 years and up to 20 years in prison. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Also, I'm sorry.
On this.
Let me see the trial court certification. I just need to change the date. I'm gonna handwrite it. Because that's from the other one. Also, I am making a finding. There was a previous bond forfeiture in this case dated April 28th of 2026. All right, you can go back with the bailiff. Good luck to, well, here, let me, hold on. There you go.
Thanks, Judge.
Thank you, Mr. Plum. And then. So, Mr. Lewis and Mr. Smith, we've got that hearing on Herlin Romar. It's my understanding you guys have reached an agreement. Is that correct? Oh, where's Mr. Smith?
You just stepped outside.
Is there a sentencing on Herlin Romar over there?
You may be talking to please. Yeah. Speaking with this judge.